And welcome back. That was the opening statement of the defense attorney in the sentencing phase of Anthony Kirkland. I'm here with two guests. One is Mike Carbonix, who has stuck with me for the past hour and is going to continue on. And our new guest, which is Don Papcsy. Did I say it right?
You did, yes.
You are a Connecticut criminal defense attorney in personal injury. And so the common theme between the three of us seems to be that we are all being put to sleep, which is never a good thing when you are trying to save the life of your client in a death penalty phase. What are your thoughts, Don?
We were talking about it off camera for a minute. I think I was falling asleep a little bit when you needed to be woken up. I mean, your life's at risk here. You'd hope that your attorney is going to give some sort of an impassioned plea to keep you alive, and that's what you want from the person that's representing you. To not only just give the sort of facts and to lull the juries. They have a limited time span, a limited attention span to be able to pay attention to what you have to tell them. And when you're just sort of droning on like that in that type of voice, you're going to lose them very quickly.
Yeah, Mike, I mean, this is not the person I would want to be handling my case. And quite frankly, there's a feeling I get when I listen to this that he's given up, which is not what you want when you're the defendant in something as serious as a death penalty murder sentencing. I mean, it's kind of unusual to see.
I think we're unanimous in our decision here because it is a little amazing to me that and usually death penalty lawyers are very experienced.
Right.
They don't give them to just any lawyer. It's really never your first case. You've at least sat through watching somebody else, they refer to him in New Jersey federal courts as learned counsel. And it just doesn't appear that his heart's into it at all. And if there's going to be testimony that he's given a preview to, maybe know your strengths and know maybe I should just give you a very small preview and let the experts talk about it, because he obviously is missing something in his delivery.
Yeah, absolutely. And one of the things I will say is the things he's saying, if you're able to stay awake, are important. This is a defendant who basically attempted to go to a hospital for years to try to get help and didn't get that help. And so there becomes a question about whether society and whether the hospitals and doctors failed him. Obviously not an excuse for this, but mitigation that I think the jury would really want to consider when they're making a decision about something so serious. And yet it seems to me that it's lost on us as the listener and on the jurors, because honestly, he doesn't seem to be vested in it at all, Well,
the thing that really stuck out to me is you're right. I thought that was like the drive home point. And there's nothing worse, and maybe it's just a question of style, is when you see an attorney and the most important part of his case, he's reading from his notes. That makes it almost seem like he might have just picked up the case last night and is not really sure about it. Those kind of things, that should be so ingrained in your mind and in your heart and ready to articulate to the jury that you shouldn't be looking at your notes, because the jury is wondering what you know about the case.
Sure. I mean, look, I think there's some attorneys that are able to get up there and speak without even taking a look at anything. And then there's some attorneys, I sometimes take a look at a note just quite frankly, out of force of habit. But I think there's a level of dispassionateness that comes with him and seems to have an impact on whether or not anyone's going to be truly listening to him. The things he is saying in regards to his mental illness, I think are incredibly important. I think one of the things that we may be lost on is that the fact is that at least some of the times he went to the hospital, he had already killed some of his victims. And so that becomes an issue, obviously, for the jury to consider. We're going to now take a look at a clip of Anthony Kirkland when he's again speaking to the detectives, and he shows some emotion about what had transpired.
I can't control me. Well, and I understand that. I can't keep happiness. And this is what I said. You can't. And this is where it stops. This is where it stops. Is there anything else? I'm going to take a break here. I'll get you some more water if you want it or something. I really don't be able to be able to shine today. I really was. takes a while for people to admit that they did something wrong.
But it was since it didn't have to be.
Right.
And another thing that, it really was fair in that case, in them cases.
Okay.
When they cases, and even though I know I hadn't eaten, although I hadn't drank, I still had no.
You knew right from wrong.
But that's the truth.
And you knew that you shouldn't have had sex with that girl, but you did, and you're own up to it. I mean, you shouldn't have killed her, but you did. But the fourth thing is you owned up to it.
There was also things that certain situations, at certain times, there was situations taken advantage of. We basically believe it was like.
And you're listening to the testimony or the statement of Anthony Kirkland that he made to detectives just a day after the murder of Esme Kenny. I just want to ask you, Don, this is the first time that you hear the defendant incredibly emotional about his lack of ability to control himself when it came to the murders of these women. Does it help the prosecution? Does it help the defense? What do you think?
The defense is hoping that it helps them.
Right.
And on top of everything, you have a prosecutor here who's been extremely overboard when it comes to the death penalty phase. I mean, he's really putting on almost another trial. And the more he does that, the more he's almost proving the defense's point in a way, because he's showing that this person, maybe the more he calls him a monster, an insane monster, a person, how could they do all these things? It sort of plays maybe into the defense's hands just a little bit, because they can show, yes, only an insane person would do these things. And that's exactly what we're dealing with here. And we have the medical documentation to prove that.
We're going to take a break, and we're going to talk a little bit more about the Anthony Kirkland case. Welcome back to the Anthony Kirkland sentencing case. It was out of Ohio. He was convicted in 2010, sentenced to death. The sentencing was reversed, and they did a resentencing, and this is what we're following. We're now going to go back into the rewind and take a look at Dr. Wu. Dr. Wu testified for the defense and talked a little bit about Anthony Kirkland, his prior injuries, and how they may have impacted him when it came to the murders of these young women. Let's take a look.
And what does that tell us?
Well, the scan findings show that there are metabolic decreases in frontal cortex relative to occipital cortex and decreased neocortical to cerebral ratio.
And what does that mean, Doctor?
Well, the front of the brain and the back of the brain on the occipital cortex are generally approximately symmetrical or equal in normal individuals. But in Mr. Kirkland, there is an abnormality in the relationship of the frontal cortex relative to the occipital cortex, with the occipital cortex being much higher and the frontal cortex being much lower compared to each other than is normal. And so this is a significant clinical abnormality that indicates that it's consistent with a frontal lobe injury.
And so these tests show there was trauma to the front part of the brain.
They show evidence consistent with multiple head trauma to the brain, yes.
And that's the testimony or the deposition of Dr. Joseph Wu, who was testifying that the injuries or the brain injuries to Anthony Kirkland could have impacted his behavior, and I guess trying to impact or indicate to the jury that somehow that impacted his ability to control his behavior when it came to the murder of these four innocent young women. I just want to start with you, Don Papcsy. I believe, and I could be wrong, that the defense attorney initially said that the injuries happened prior to 2006, but he had murdered before in 1987. And so if that's the case, then one has to say, well, if he already murdered before the injury, then how impactful is Dr. Wu's testimony about him being injured at a time after he had already committed a murder?
I think they're probably at a stage now where they're just throwing everything in the kitchen sink and seeing what comes up. Maybe they're making an allegation because some of those murders he had already pled to and gotten sentenced for. So they're trying to say that afterwards maybe he became more psychotic than he already was, and that led him to these other deaths later on. He wasn't able to be rehabilitated like a normal person would through the system, and maybe that's sort of the correlation they can make later on in closes. I guess we're going to have to wait till closing arguments to find out. Sure,
and Mike, we talked about this earlier, the idea that, we have obviously witnesses that couldn't come in because of the second sentencing phase. We had, so some people, we had depositions, sometimes we heard transcripts. You're the defense attorney in this case. Are you going to allow a deposition to come in on the life and death decision of this juror? Are you going to bring in a doctor who's going to be able to look at these jurors and say, you shouldn't put him to death for the following mitigating reasons? Because to me, it is lost on the jurors to be listening to a tape of an individual that is pleading basically at the end of the day for this person's life.
Well, I think more so with an expert. I mean, I think an expert that's really going to save the day here. And this expert seems so distant. Even when he talks, it just seems like there's distance between him and the jury. He's using phrases that is difficult for anybody to understand, probably fellow experts. And it just seems, the one thing though I was a little surprised at when I heard his testimony, there appeared to be a missing link between what the attorney opened to when he put so much significance on this bike accident, one bike accident. He actually was describing the ratio between the cerebellum and the other cortex of the brain as being a result of multiple traumas. So that means that it wasn't like once you fell off your bike. I mean, I think that's pretty tough for a jury to say, oh, the guy fell off his bike and that's an excuse for all this. But it appears that maybe he went through trauma multiple times, maybe through his childhood and things of that nature. And I just was very surprised that the expert testified multiple and the defense attorney made it sound like in passing he fell off his bike. That was a little shocking to me.
So it's probably something that needed to be explored a little bit further. We're now going to hear from Dr. Alan Waxman. He was the prosecution witness who talked about kind of the opposite of what Dr. Wu said. Let's take a look.
What did the doctors at Ohio State University find when they did the scans on Anthony Kirkland?
Well, the first thing I did was I didn't look at their report. I actually looked at the scan and tried to get an impression. I don't want to be biased. I looked at the scan and it was a textbook normal study. And I would have been surprised had the study been interpreted as abnormal by the Ohio State doctors, which they did not. They called it normal all the way through. And I agreed with that interpretation.
So when you say normal, you're saying they found no evidence of traumatic brain injury in Anthony Kirkland?
That's correct.
And when you examined that, you agreed with them?
I didn't find any evidence of anything wrong with the brain.
Okay. And then you looked at Dr. Wu's report, obviously. What did Dr. Wu find when he examined Anthony Kirkland?
Usually his reports are very, very similar, and I actually predicted. Sorry.
And that's the testimony of Dr. Alan Waxman, who actually, he said something really interesting. What he said is that he didn't take a look at any of the reports from any of the other experts. Instead, the first thing he did was look at the pictures of the brain himself to make his own determination as to whether or not the brain looked normal. And it looked normal. He didn't want to have any bias by looking at any other person's report. Mike, I'm going to come back to you. So now we have a doctor who's basically saying the brain of Anthony Kirkland is completely normal. That cannot bode well in any way, shape, or form for the defense.
No, not at all. And also when he tailed off, I was a little surprised. He said he was familiar with Dr. Wu's reports, and they usually all are similar. Right. So I don't know where that was going, but that was not helpful at all.
No, and let's talk about that, Papcsy. Like, it sounds as though there is a mocking way about Dr. Waxman, where he seems to think that Dr. Wu always seems to find the same thing, which is something wrong that isn't there.
I've been in that position before where all of a sudden the opposing counsel just breaks out reports and literally it's almost word for word of the report that you got from them because they're hired for different types of cases. And
right.
It's never good. It never plays well in front of the jury.
But I think that's the job of the defense attorneys to make sure that's not who your doctor is. I mean, it seems as though look, Anthony Kirkland committed a horrible, horrible, horrible crime, but it's the defense that has a job to do,
Part of the problem is, too, though, is, when you speak about your defense, and unfortunately, finances come into it. This is a public defender case. I'm sure this is one of the limited numbers of experts they have to use, and that's what happens. There's a lot of material if that person constantly is testifying.
We're going to throw to a break, and we're going to come back and talk more about the Anthony Kirkland case. Thank you.
Wu took 70-something people that had normal brains and did his own little study, got scans done of them. And any one of them would have been normal. But then what he does, he combines them all and makes a perfect brain. And that's what he uses when he does these brain scans. Unless you match that perfect brain, you're not normal. And Dr. Waxman's studied this guy because it bothers him. They're in the same field. He doesn't like people doing this. He says he has found 1,000 cases where Wu has done a brain scan and he could only find one that Wu said was normal. Dr. Wu himself, when Mr. Gibson cross-examined him, just name me one. Name one person you've done a brain scan on that came back normal. He couldn't do it because that's not what he's paid.
Now that is a prosecution closing argument that I respect. Compare that, Mike, to the opening statements of the defense. There's such a variance in terms of how they handle themselves. And by the way, this prosecutor is reading partially, and yet he still has such an incredible impact in what he's saying and what he's telling this jury.
This is a old school, strong, right to the point. I think he talked on something we spoke about earlier, was the way experts think and talk to the jurors to understand it. When he used that analogy with his hands, that's something everybody could get to.
Sure.
And I thought that was really, really effective.
Yeah, no, and Don, we really do have to compare him to, the person that is there to attempt to save Anthony Kirkland's life. And the question is, for me, is, on top of him giving what I consider an absolutely brilliant closing argument, is that he had tons to work with. And look, a lot of times, prosecutors have a lot to work with, but the question that I can't help but ask is, did he have a lot to work with because the defense failed, or did he have a lot to work with because the defense just had nowhere to go?
I think he had a lot of work. I think he had a lot to work with because of the way things played out in the actual case. But I agree with my colleague and the fact that the way he laid out everything, he lays out the element that he has to prove, and then he gives an example. Then he lays out the next element, then he gives an example, and then he lays out the next element. And he does it in such perfect format and he takes pauses in the right spots where the jury can really let that soak in. I was taught once to really let the motion slow down like it's a film when you get to really important moments. And he knows how to do that and really draw them in. He's fantastic.
Yeah, he did an absolutely beautiful job. And I think that, unfortunately, or fortunately, obviously, that he did have a lot to work with. When we come back in a few minutes, we're going to hear the defense closing arguments, and one of the things we're going to have an opportunity to do is compare and contrast the prosecutor's closing arguments with the defense closing arguments and see kind of the difference and who had the greatest impact on this jury. We're going to take a break, and we'll be right back.
You'll see the reports. The child who sought revenge at age 13 against an abusive, alcoholic father. You'll see this in Dr. Van Nuys' report. The child who picked up a big chunk of ice and threw it at a bus his father was driving. The child who ran, who was chased by the father. This child, this teenager, never had a chance.
And that's the defense closing arguments. And Anthony Kirkland, I want to turn to my guest. This is much more passionate than we saw before in the defense opening statements. Mike, what are your thoughts?
Well, obviously there's a reason why this attorney gave the closing. He just seemed to be more in tune with this, gave better explanations, and really tied it together. I like the one phrase he used in the defense point that Anthony Kirkland never had a chance.
Right.
That this was all normal living that was shown to him in his early stages of his life. I think he did the best with what he had.
Yeah, I mean, Don, I think, look, we had the opening statements from the defense, and I think we fell asleep. We were certainly awake for this, and I think that a lot of what he had to say was pretty riveting. I think one of the concerns always when it comes to these type of sentencing phases and when the defense is speaking about his childhood is a lot of that testimony that comes in is based on what Anthony Kirkland tells them. And so there's a question as to whether or not Anthony Kirkland's even being forthright about what happened in his childhood for the jury to decide whether or not to even give it any credibility. So that I would think has an impact when the jury's listening to this to decide the truthfulness of it.
It probably does, but when you were watching that defense attorney in general, I mean, Mr. Kirkland was thrilled, like, yes, finally,
Right.
I have somebody that's making a plea on my behalf that might be able to work. But he was in a situation where there was the similarities between him and the prosecutor that did the opening argument were almost identical. You saw how he did the pauses at the right time. He let people soak in what he was saying about, what kind of upbringing this kid had. And, this was a house, it wasn't a home that you traditionally, but people think of as a home where you get
Right.
emotional support and things like that in your life. He had a father who was abusive to him. And he was really hitting home those points, which is what he needs to do if by any chance he has any chance of what he wants to get, which is probably a life imprisonment.
Right. And look, we all know this is an uphill battle when it comes to the defense trying to convince this jury not to sentence him to death. And we don't get to see the whole thing. We only see a clip of, what we're watching. But the question I have is, one of the things I think is missing, and it may, we didn't get to hear the whole thing, is that do you really want to focus just on the defendant in a sense, or do you want the jury to understand kind of that humanity, that you recognize that there are 4 victims that died and that there's absolutely no excuse in the world, but that there's just a little bit of mitigation that maybe just can save his life. He'll be in jail for the rest of his life. And as a defense attorney, I don't think you want to lose that either, because you want the jury to find you credible in every way.
Well, I always think in those instances, you're right. You've got to try to somehow reach that jury and get them to open their heart with some form of compassion, and that everybody in humanity is entitled to that form of compassion, and that no matter what you do today, there's just going to be another loss of life.
Yeah, great point. We're going to head back in and we're going to take a look at the verdict. Let's take a look.
Thank you very much, ladies and gentlemen. You will now hear your verdicts read for the record. State of Ohio versus Anthony Kirkland, case number B0901629, Judge Dinkelacher, verdict count 2. We, the jury, being duly impaneled and sworn, do hereby find by proof beyond a reasonable doubt that the aggravating circumstances that the defendant was found guilty of committing do outweigh the mitigating factors presented in the case regarding the aggravated murder of Cassandra Crawford. We therefore unanimously find that the sentence of death should be imposed upon Anthony Kirkland, as signed by all 12 jurors, including the foreperson. The next verdict form, same exact caption, verdict count 4. We, the jury, being duly impaneled and sworn, do hereby find by proof beyond a reasonable doubt that the aggravating circumstances that the defendant was found guilty of committing do outweigh the mitigating factors presented in the case regarding the aggravated murder of Cassandra Crawford. We therefore unanimously find that the sentence of death should be imposed upon Anthony Kirkland, signed by all 12 jurors, including the foreperson. Next verdict form, same exact caption, verdict count 9. We, the jury, being duly impaneled and sworn, do hereby find by proof beyond a reasonable doubt that the aggravating circumstances that the defendant was found guilty of committing do outweigh the mitigating factors presented in the case regarding the aggravated murder of Esme Kenny. We therefore unanimously find that the sentence of death should be imposed upon Anthony Kirkland, signed by all 12 jurors, including the foreperson. The final verdict form, same exact caption, verdict count 11. We, the jury, being duly impaneled and sworn, do hereby find by proof beyond a reasonable doubt that the aggravating circumstances that the defendant was found guilty of committing do outweigh the mitigating factors presented in the case regarding the aggravated murder of Esme Kennedy. We therefore unanimously find that the sentence of death should be imposed upon Anthony Kirkland, signed by all 12 jurors, including the foreperson.
And as is probably not a surprise to those who are watching, the jury came back unanimously that the aggravating factors outweighed mitigation, and therefore he is going to be sentenced and is sentenced to death. I just want to bring in my experts one last moment. Surprise for you?
No, not at all. Just by the comments we had today, you knew where this was going.
Yeah, it seems, look, I think we all agree, Don, that they had, major hurdles to try to get over in order for them to even get anywhere near even one juror coming back and finding him to potentially save his life. So I assume it's not a surprise for you either when we're watching this.
No surprise at all. It was overwhelming evidence against him for aggravating versus mitigating.
Yeah, and so I want to thank you both for being here and spending time talking about this case with me. I know this is, one of many cases that we cover that are extremely emotional, and especially the death of 4 young women. We're going to hear now from Aaron Keller with the Daily Debrief. Please stay tuned. Thank you very much.